February 2026 just became the most important month for gun owners in a very long time. On February 19, 2026, a federal appeals court handed down one of the broadest gun rights decisions in decades. Legal scholars are already calling it the most consequential lower court Second Amendment ruling since the Supreme Court changed the entire constitutional standard for how these cases are judged. 10 categories of gun law just changed. Some of those changes apply immediately in the states directly tied to this ruling. Others are creating legal precedent that gun rights organizations are already using to file challenges in states that were not even part of this case. Either way, the ripple effects are hitting every single gun owner in this country, whether you know it yet or not. Here's the part that is genuinely hard to believe until you go through all 10. Some of the things that could have gotten you arrested last month are completely legal today. Not in a few months, not pending some future appeal, right now, today. And on the flip side, some things you assumed were fine now have different rules attached to them. Both directions matter. Getting either one wrong has real consequences. I am going to walk you through all 10 changes one by one. No legal jargon, no filler, just exactly what changed, exactly why the court ruled that way, and exactly what it means for you today. By the end of this video, you will have a clear and complete picture of where the law actually stands. Before we get into change number 1, I need to say something important. About 60% of the people watching this video right now are not subscribed to this channel. That means 60% of you are going to miss the follow-up when this ruling generates new court challenges, new state legislative responses, and new decisions. And it will, because this is not over. States are already holding emergency sessions, attorneys general are already filing papers, courts are already receiving new arguments built on top of this decision. When those developments hit, I cover them immediately and break them down in plain language so you know exactly what changed and what you need to do. If you are not subscribed with notifications on, you will not get that information in time. Hit subscribe right now before we go any further. Let me set the stage for how we got here, because this ruling did not come out of nowhere, and understanding the background makes every one of these 10 changes make more sense. For the past several years, Second Amendment cases in federal courts have been decided using a framework established by the Supreme Court that fundamentally changed the rules. Courts can no longer simply decide that a gun law seems reasonable, or that the government has good intentions. They now have to ask a very specific question. Is this law actually grounded in the historical tradition of American firearms regulation? If a state cannot point to a genuine historical analog for the restriction it is trying to enforce, the law does not survive. And what the February 19th ruling revealed is that a huge number of state-level gun restrictions have no real historical foundation. They were policy preferences dressed up as constitutional regulations. And one by one, the court knocked them down. The reason this matters beyond just the immediate states involved is the legal reasoning behind it. That reasoning is now precedent. Other federal courts have to take it seriously. Gun rights organizations are already using this decision as a blueprint to file challenges in states that had similar laws on the books. So while some of these 10 changes apply directly and immediately, all of them signal where American gun law is heading. You need to understand all of them. The first change is the one that most gun owners have been waiting for longer than almost anything else. Magazine capacity limits are now an unconstitutional restriction on your Second Amendment rights in the states covered by this ruling. The court's reasoning was direct and hard to argue with. Your right to self-defense does not come with a government-mandated round count attached to it. If you are in a genuine defensive situation, if you are facing multiple attackers, if the first shots do not stop the threat, limiting you to 10 rounds is not a public safety measure. It is a disadvantage that the government is imposing on a law-abiding citizen trying to protect their life. The court looked for a historical basis for magazine capacity limits and found none. There is no tradition in American history of the government restricting how many rounds a citizen could load into a firearm. These laws were modern policy inventions with no constitutional foundation, and they fell. What this means practically is significant. If you live in a state that was covered by this ruling and had a 10-round or 15-round magazine limit, those limits are no longer enforceable. Magazines you owned legally, magazines you stored away and never used, magazines you bought and held on to waiting for exactly this moment, they are all usable now. That said, I need to be specific here because this is exactly where people make mistakes. This ruling directly covers the states that were parties to the lawsuit. If your state was not directly involved in this case, your old magazine law may still technically be on the books, even if it is now legally vulnerable and likely to fall. Do not assume you are covered without checking. Verify your specific state's status. I will tell you how to do that at the end of this video. The second change is one that has been building in the courts for a long time, and the reasoning the court used is genuinely sharp. Several states had laws banning certain semi-automatic rifles, not because of how they function mechanically, but because of how they look. pistol grips, adjustable stocks, threaded barrels, folding stocks. The court took a hard look at these so-called cosmetic bans and ruled them unconstitutional, and the logic is difficult to dismiss. A rifle with an adjustable stock fires the exact same round at the exact same rate from the exact same magazine as the same rifle without an adjustable stock. The features these laws targeted do not make a firearm more lethal in any technical or measurable sense. They make it more ergonomic and more adaptable to different shooters. The court found that banning a firearm based on how it looks while leaving a functionally identical firearm perfectly legal is arbitrary, inconsistent, and constitutionally unsupportable. Think about what that actually meant in practice before this ruling. The exact same rifle was legal or illegal in some states, depending on whether it had a thumbhole stock or a pistol grip. Two guns with identical mechanics, identical calibers, identical magazine capacity. One was a felony to own and one was not, based entirely on a design feature that had nothing to do with lethality. The court said that makes no sense under the Second Amendment, and they are right. If you live in a state affected by this ruling, rifles that were previously banned solely because of their features may now be legal to own. But here is what I need you to hear clearly. This does not erase every assault weapon ban everywhere overnight. Some bans are more broadly written and cover different criteria beyond just cosmetic features. The line between what is now legal and what is still restricted can be very thin in some jurisdictions. Check your specific state law before you do anything. The third change surprised a lot of people because waiting periods had seemed like one of the more legally durable restrictions. But the court struck down mandatory waiting periods beyond 72 hours, and the reasoning is both legally sound and practically compelling. The court's standard was clear. If a state cannot demonstrate with actual evidence that an extended waiting period prevents a specific measurable category of harm, that waiting period is an unconstitutional burden on a fundamental right, most states could not meet that burden. The data simply does not show that making someone wait 10 or 14 days after they have already passed a background check prevents crime in any statistically meaningful way. The background check is the safety mechanism. Once you pass it, the government already has every piece of information it needs. Making you wait 2 weeks after that point is not a safety measure. It is an obstacle. And the court made another point that carries real weight. For someone facing a credible, immediate threat to their safety, a mandatory 2-week waiting period is not a minor inconvenience. It could be catastrophic. A person being stalked, someone who has just received a credible threat, someone in a dangerous situation who needs the ability to protect themselves today and not next month. The government cannot tell that person their constitutional right is valid in theory, but will have to wait until the state decides it is convenient. What this means for you is that in the affected states, if you buy a firearm and pass your background check, you should be able to take that firearm home the same day or within 3 days at most. That is a fundamental change in how gun purchases work in several states that had extended waiting periods on the books. Now I want to stop here for a moment because I want to make sure you understand something that most gun owners underestimate. A survey found that roughly 40% of gun owners in America do not know the current laws in their own state. 40%. These are not reckless people. These are regular gun owners who simply do not have a reliable source that tracks these changes in real time and explains what they actually mean. Those are the people who end up losing their rights or facing charges over something completely avoidable. That is exactly why this channel exists. Subscribe right now and turn on notifications. My next video drops in 48 hours covering the 5 most common legal mistakes gun owners make in the weeks right after a major ruling like this one. The fourth change is where this ruling gets genuinely aggressive in a way that is going to affect how gun owners interact with everyday public spaces. For years, certain states built what legal experts started calling sensitive place expansions, laws that made it illegal to carry a firearm in any privately owned space open to the public unless the owner had explicitly posted a sign permitting it. Restaurants, banks, grocery stores, parking lots. Essentially, the default in those states was that your carry permit was meaningless everywhere unless you found a specific affirmative invitation to exercise it. The court drove a stake through that approach. The ruling established a principle that is both legally sound and practically obvious. The default state of a constitutional right cannot be prohibition. If you have a valid carry permit, the government cannot structure the law so that right only functions in a narrow set of approved spaces while being effectively banned everywhere else. But there is a critical nuance here that you absolutely need to understand because this is where people will make mistakes. The court also addressed what it calls sensitive places, and it maintained that designation for certain specific locations. However, it added a condition that changes everything. If a government entity wants to declare a space gun-free, it now must provide a meaningful alternative for the safety of the people it is disarming. The court's principle was straightforward. If the state takes away your ability to protect yourself in a specific place, the state assumes the duty to protect you in that place. A no-gun sign does not protect anyone. It just disarms the law-abiding people who read it. So publicly accessible spaces like parks, bus stations, transit hubs, and certain government buildings that previously banned firearms but had no actual security presence, no metal detectors, no armed guards, cannot legally enforce those bans anymore. Private property owners still absolutely set their own rules on their own premises. Schools operate under federal law. Federal buildings are governed by federal regulations, not this ruling. Courthouses have their own specific rules. But for that broad category of public spaces where gun-free signs were everywhere and actual security was nowhere, the legal landscape has fundamentally shifted. The fifth change is one that hits gun owners directly in the wallet, and the court sent a message here that is impossible to misread. You cannot price people out of a constitutional right. Several states had structured their concealed carry licensing systems in ways that made them extraordinarily expensive and time-consuming, not because those requirements actually made anyone safer, but because they functioned as barriers designed to discourage people from exercising their rights. Fees of $300 or $400 just to apply, mandatory training courses that required multiple weekends of your time and hundreds more dollars, appointment systems with months-long wait times. The court found that when you look at these systems honestly, they were not designed to inform or protect, they were designed to obstruct. And obstructing the exercise of a constitutional right through administrative and financial barriers is itself unconstitutional. Background checks remain valid. The government can still prohibit certain people from owning firearms. Basic safety education requirements can still be required, but a system that charges a working person $600 and requires them to take what amounts to a college semester-length course just to legally carry a firearm for self-defense? The court said that is not regulation, that is a wealth barrier, and wealth barriers to constitutional rights do not survive legal scrutiny. States affected by this ruling are being forced to redesign their permit systems from scratch. Some already have attorneys working on it. That process takes time, but the legal foundation those expensive systems rested on has now been knocked out from under them. The sixth change is more technical than the others, but it has a direct and meaningful impact on your options as a consumer and on the long-term health of the firearms market in states where gun shops have been struggling. Some states built secondary licensing systems on top of the federal firearms dealer licensing that already exists. Even if a dealer had a valid FFL from the ATF, the state would require a second, separate state-level license that came with enormous fees, complicated compliance requirements, and record-keeping demands that went far beyond anything the federal government required. The practical effect was that small and independent gun dealers in states like Illinois and New York were being squeezed out of business one by one. The court ruled that states cannot impose licensing requirements on firearms dealers that go beyond what federal law already requires, if those requirements serve no legitimate safety purpose and function primarily to burden and eliminate small businesses. When local gun shops disappear, prices go up, selection shrinks, and consumers have fewer options. This ruling creates the conditions for more competition to return to markets where it had been regulated away. The seventh change is one of the most nuanced in this entire ruling, and it is critically important to understand what the court actually said here versus what some people are going to claim it said. The court did not eliminate red flag laws. Let me be direct and clear about that, because there is already misinformation spreading. What the court did was establish strict, non-negotiable procedural requirements for how red flag laws can be used. Before this ruling, some states allowed law enforcement to seize a person's firearms based on a petition and very limited judicial review. The person whose guns were taken might not get a proper hearing for weeks or even months afterward. The court ruled that this is a fundamental due process violation. You cannot strip a citizen of a constitutional right and then leave them waiting indefinitely for the chance to challenge it. Under the standard the court just established, if someone petitions to have your firearms taken under an emergency red flag order, you are entitled to a hearing in front of a judge within 72 hours, not weeks, not months, 72 hours. At that hearing, you have the right to an attorney, you have the right to see the evidence being used against you, you have the right to present your own evidence and challenge the claims being made. The court's logic was grounded in the 14th Amendment, taking a citizen's property and stripping them of a constitutional right without immediate, meaningful judicial review is a due process violation. This change does not protect people who are genuinely dangerous from appropriate legal intervention. It protects law-abiding gun owners from having their rights taken away based on bad information or bad faith petitions with no real opportunity to respond. Both of those things matter, and they are not in conflict with each other. The eighth change will be particularly welcome news for anyone who has dealt with ammunition restrictions. The court ruled that if the firearm is what the Second Amendment protects, then the ammunition is functionally inseparable from that right. You cannot have one without the other. As one judge wrote in the decision, a gun without ammunition is an expensive club. It is not a tool of self-defense. Restricting your ability to purchase the ammunition necessary to exercise your constitutional right is functionally the same as restricting the right itself. Several states had passed laws requiring a background check every single time a person bought ammunition. Some had limits on how much you could purchase in a given period. Others had created bureaucratic systems that made online ammunition purchases nearly impossible. The court struck all of these down. In the affected jurisdictions, you can now purchase ammunition without going through a separate approval process, and without being told you have hit some arbitrary purchase limit. For those of you who buy in bulk to save money or for competitive shooting, this is a meaningful, practical change. The ninth change comes with important nuance, and I want to be precise here because misunderstanding this one has real consequences. The court ruled that the government cannot dictate how you store your firearms inside your own home when no minors are present. Some states had mandatory storage laws that required trigger locks, gun safes with specific specifications, or other measures, even if you lived alone or only with other adults. The court's reasoning tied directly back to the Heller decision. A firearm kept for home defense must be operable and accessible when you need it. If the law requires your handgun to be locked in a safe, unloaded, with the magazine stored separately in another room, you do not meaningfully have a right to self-defense. You have a right to eventually get to a firearm after spending critical minutes unlocking and assembling it while something dangerous is happening. The court said that is not what the Second Amendment protects. But here's the part you need to hear just as clearly as the rest. If you have children in your home, child access prevention laws in many jurisdictions remain valid and remain enforceable. This ruling was not giving anyone permission to be careless with firearms around kids. If minors are present in your household, safe storage remains a legal responsibility in many states, and more importantly, it is simply the right thing to do. The distinction the court drew is real and specific. Adults only household, your storage choices are yours to make. Children present, the responsibility for keeping those firearms secure from them remains. The 10th and final change is arguably the most significant from a long-term rights perspective, and it is the one with the most important action item attached to it. The court ruled that states cannot compel gun owners to register their firearms in a government database. The reasoning draws on both Second Amendment grounds and fundamental privacy principles. The court noted accurately that the historical record shows registration systems have repeatedly served as a prerequisite for confiscation. Building a mandatory, searchable database of which law-abiding citizens own which specific firearms creates infrastructure that goes well beyond any reasonable regulatory purpose and imposes a chilling effect on gun ownership itself. States with mandatory registration systems are now prohibited from enforcing those requirements going forward. But here's the part I need you to act on, and I'm going to be direct with you about this because the optimistic version of this story leaves out something important. If you previously registered firearms in a state that had a mandatory registry, that registry has been ruled unconstitutional and your data is supposed to be purged. But government databases do not tend to erase themselves quickly, completely, or without being pushed. Do not assume your information is going to disappear on its own on a clean timeline. If your data is in a state registry that has now been ruled unconstitutional, you may need to affirmatively file paperwork to get your information removed from that system. The right move here is to contact a firearms attorney in your state or reach out to your state's gun rights organization for guidance on exactly how to do that and what documentation you need. Now let me give you the full picture because there is something critical that gets lost in the excitement around a ruling like this one. 10 categories of law just changed in ways that are genuinely significant for gun owners. Magazine limits, semi-automatic rifle bans based on cosmetic features, extended waiting periods beyond 72 hours, blanket gun-free zone designations without any real security presence, excessive permit fees and training requirements designed to function as barriers, redundant state-level dealer licensing, red flag law procedures that bypassed due process, ammunition purchase restrictions, mandatory storage laws in adult-only homes, and mandatory gun registries. All 10 look fundamentally different today than they did on February 18th. That is real and it matters, and you should understand it clearly. But here is what the people who benefit most from this ruling will understand, and what the people who end up in trouble will miss. Anti-gun legislators in several of the affected states are already in emergency sessions. They are not accepting this ruling and walking away. They are working right now to find new approaches, new legislative language, and new frameworks that technically comply with this decision while still making gun ownership and carry as difficult as possible. The legal fight does not end with this ruling. It moves to a new battlefield. The people who will be caught off guard are the ones who hear about these 10 changes, assume everything is settled, stop paying attention, and walk into a legal situation they did not see coming because a replacement law quietly passed while they were not watching. That is a predictable and avoidable outcome, and staying informed is the only thing that prevents it. Here is what you should actually do right now based on everything we just covered. First, find out whether your state was directly part of this case. That single fact determines which of these 10 changes apply to you immediately versus which ones are still developing in your jurisdiction. Your state attorney general's office, your state's gun rights organization, and reputable firearms law websites are good starting points. Second, for anything you are genuinely uncertain about, talk to a local firearms attorney who practices in your specific state. The stakes are too high to rely on secondhand information. Third, do not overreach. Federal law is fully in effect. You still cannot be a prohibited person and own a firearm. Background checks at licensed dealers are still required. Carrying while intoxicated is still illegal. What changed is the ceiling of how far above the constitutional floor states are allowed to build. Fourth, stay informed. This ruling is going to generate new lawsuits, new state legislation, new appeals, and new decisions for months. That is what this channel is built to do. If you are not subscribed yet, do it now and turn on notifications so you catch every update the moment it drops. In 2 days, I am posting a breakdown of the 5 most common mistakes gun owners make in the weeks right after a major ruling like this one, when everyone is moving fast and excited and sometimes moving wrong. One of those mistakes involves crossing state lines in ways that people assume are now covered by these changes but are not. That single mistake can cost you your firearms rights, even with everything this ruling just established. You will want to see that video before you do anything based on what we covered today. The information you carry out of this video is your first line of defense. Stay informed. Exercise your rights responsibly. And I will see you in the next one.